Hi, welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We cover 4 fundamental questions in this series, and today we are talking about the 4th, which is holding interest in property. And we are going to talk about the perhaps surprising revelation that your interest in property may be completely taken away from you by government. Not only is this constitutional, but the very mechanism for doing so is written into the Constitution itself. So the Constitution's Fifth Amendment has a clause we call the Takings Clause. It says, quote, "Nor shall private property be taken for public use without just compensation," end quote. This clause applies to the federal government and to the states via the 14th Amendment. We will consider its many aspects in over a dozen videos in this series. In this video, an introductory video, it's important to understand that the Takings Clause offers governments a power and constrains it in only 2 ways. The property must be taken for public use, and the property owner has to be given just compensation. As noted, the Takings Clause does not ban government from taking property. So with that in mind, let's move on to 4 elements of the Takings Clause itself. First, private property, then be taken, then public use, then just compensation rather. All right, so private property. This is simple. It means any property not owned by government. And it can include parts of a piece of property. For example, it can include a surface estate or a mineral estate. It can also include all kinds of property, real property, land, and personal property, including intellectual property or even financial assets. The next phrase, to be taken, has 2 dimensions, physical and regulatory. A taking can be a physical taking. Government can itself physically own or occupy the property or require a property to be physically occupied. The way that government itself comes to own property through the process of eminent domain falls into the first category. There are also situations where government allows someone else, like a cable company running lines through a neighborhood, to physically occupy private property. We actually consider a cable company case in a video about Loretto versus Teleprompter Manhattan. A taking can also be a regulatory taking. So what that means is that government can pass laws which prevent property owners from having full use of their property. We cover regulatory takings in many other videos in this series. The third phrase, public use, is extremely important. Without a public use, government cannot take private property. There are 3 basic ways that a state can establish a public use. So first, the state can actually take property for public ownership, like for a road or a hospital or a military base. The process for doing so is called eminent domain, discussed in other videos. The second way states can show a public use is when a state takes property for certain private parties, like common carriers who make the property available for a public use, like railroads or public utilities or stadiums. This type of public use, like the first, is well established by courts. It's the third type of public use, the type where states take private property and transfer it to private properties for other reasons, that's a little bit trickier. It's clear that government can't take property for purely private uses, but the extent to which government can transfer property to private parties is where we see significant debate and judicial activity. And finally, just compensation. This phrase includes the word just to suggest fairness. But within that broad category, there is a lot of room for interpretation. There is another video focused on just compensation, and I encourage you to watch it and learn more about this important term. With that breakdown of the takings clause, I will leave it there. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time.